At Los Angeles International Airport, a dog trained to smell cash stopped at a suitcase. Inside was $230,000. By the time inspectors finished searching, the number was $357,144. The money was his. A court would later find it was clean, and that he was carrying it to pay back a debt he genuinely owed. The government tried to keep every dollar of it, not as a tax, not as evidence, as the punishment. And in 1998, for the first time in American history, the Supreme Court said a fine was so large that it broke the Constitution. This is how that happened, and the man at the center of it is not the hero you'd expect. June 9th, 1994. Josep Baja Kajian, his wife, and his two daughters were at LAX waiting to board a flight to Italy. Their final destination was Cyprus. In their bags was cash, a lot of it. Here's the part that surprises almost everyone. Taking that money out of the country was completely legal. The Supreme Court said so directly. It was, in the court's words, perfectly legal for him to possess that cash and to remove it from the United States. The law sets no cap on how much you can carry out. But there is a rule about telling the government you're doing it. Move more than $10,000 across the border, and you have to declare it. That's the whole requirement. The law didn't want his money. It wanted a form. Customs was using dogs trained to detect currency by its smell. One of them hit on the family's checked baggage. Inside was about $230,000. Then an inspector walked over to Josep and his wife and told them, out loud, that they were required to report any money over $10,000. He was told the rule, to his face, before he said a word. He answered that he had $8,000 and that his wife had another $7,000, and that the family had nothing else to declare. That was a lie. Inspectors searched the carry-on bags, the purse, the wallet. In all, they found $357,144. He had understated it by roughly $342,000. Then he started explaining where it came from. He told Customs that a friend named Abe Ajemian had lent him about $200,000. Ajemian denied it. A month later, he said a man named Saeed Farutan had lent him $170,000. Farutan said he had made no such loan, and that Bajakajian had asked him to lie for him. 6 months after that, he went back to the Ajemian story, the one that had already been contradicted. The trial judge's summary was blunt. In his words, Bajakajian has lied and has had his friends lie. The government charged him with making false statements, on top of the reporting charge. So, let's be clear about who this is. This is not a story about a traveler who forgot a form. He was told the rule, he lied about the money, then he lied twice more about where it came from, which is what makes the rest of this so strange. Because the trial court also found something the government could not disprove. The money was not connected to any other crime. He was carrying it to repay a lawful debt. It was his. Even Justice Kennedy, who would go on to dissent in this case, acknowledged that the government had no affirmative proof the money came from an illegal source. They suspected. They could not show it. So why lie about it? The judge made a finding about that too. Bajakajian had grown up as a member of the Armenian minority in Syria. The court found he failed to report the money out of fear rooted in what it called cultural differences and a distrust for the government. The Supreme Court later made clear that finding was not an excuse for the lies. The district court, it said, made it to establish that his failure to report was unrelated to any other crime. He pleaded guilty to failing to report the currency. The false statement charge was dropped as part of the deal. And then came the sentencing, which is where this case actually lives. The government asked the court to forfeit the entire $357,000. All of it, not seized as evidence, not recovered as stolen property. The trial court had already found the money wasn't tied to any other crime. The forfeiture was the punishment. The penalty was simply the money. Now, you've probably heard of forfeiture before, and it's usually a different story. Police stopping a car and taking cash from someone never charged with anything. That's civil forfeiture, and the case against the property itself. This was the other kind. Bajakajian was convicted first, and the forfeiture came at his sentencing as part of his punishment. That distinction is going to matter enormously in about 4 minutes. The judge said no. He sentenced Bajakajian to 3 years of probation and a $5,000 fine, the most the sentencing guidelines allowed. Then he ordered $15,000 forfeited. His reasoning was on the record. The guidelines fine by itself, he said, was too little. The $15,000 would make up for what I think a reasonable fine should be. $15,000 instead of $357. So the government appealed. Their argument came from the wording of the forfeiture statute, which says the court shall order forfeiture of any property involved in the offense. Shall, not may. Congress wrote it, the money was involved, the judge doesn't get to negotiate. Bajakajian's answer was 8 words long and more than 200 years old. Excessive bail shall not be required, nor excessive fines imposed. It's in the 8th Amendment, the same sentence that bans cruel and unusual punishment. Almost nobody has heard of the fine's half. There's a reason for that. In more than 2 centuries, the Supreme Court had never once struck down a fine for being too large. Not one. The clause was there the entire time, and it had never stopped anything. In 1998, it did. Justice Thomas wrote for the court, and the rule he set is 1 sentence. A punitive forfeiture violates the excessive fines clause if it is grossly disproportional to the gravity of a defendant's offense. The touchstone, the court said, is proportionality. The punishment has to bear some relationship to what you actually did. But first, the court had to get past what the government was arguing, and the government had 3 answers. 1, that taking the money served important remedial purposes. It deterred people, and it gave investigators information. 2, that this belonged to an old tradition of seizing guilty property, which was never really punishment at all. 3, that the cash was the very thing the crime was made of. Without moving it, there would be no offense at all. The court rejected all 3. And the reason it could is that distinction from earlier. This forfeiture, the court said, descends not from the historic seizures of guilty property, but from a different tradition entirely. Criminal forfeiture, imposed on a person. It required a conviction. It came at sentencing. It could never touch an innocent owner, which makes it punishment. And punishment is exactly what the excessive fines clause governs. So, the court had to decide whether this punishment fit the crime. 4 things drove the answer. First, who the law was built for. The court said flatly that he is not a money launderer, a drug trafficker, or a tax evader. His crime was the paperwork. The underlying act, moving his own money, was lawful. Second, how seriously the law itself treated it. Under the sentencing guidelines, the most he faced was 6 months and a $5,000 fine. The court read that as a sign of minimal culpability. The system had already priced this offense, and priced it low. Third, the harm. And this is the line the case turns on. There was no fraud on the United States, and respondent caused no loss to the public fisc. Nobody was defrauded. The Treasury lost nothing. There was no victim holding an empty account. What the government lost was information, the knowledge that $357,000 had left the country. Fourth, and finally, the comparison. Against that harm, the court said taking all of it bears no articulable correlation to any injury suffered by the government. And in the court's own words, the forfeiture was larger than the $5,000 fine imposed by the district court by many orders of magnitude. Grossly disproportional, the full forfeiture failed. The vote was 5-4, which means 4 justices thought the government should have kept all of it. Justice Kennedy wrote for them, and he opened by naming exactly what was happening. For the first time in its history, the court strikes down a fine as excessive under the 8th Amendment. His argument wasn't that the punishment was gentle. It was that Congress had chosen it on purpose. The penalty was set at the amount of the unreported cash. Calibrated, he said, not arbitrary. And if a fine that precise could fail, he warned, the decision threatened serious disruption across a vast range of statutory fines. He also thought the majority was shrinking the crime to fit the man. The drug trade, money laundering, and tax evasion all depend in part on smuggled and unreported cash. Then the line that lands hardest, because it points straight back at the lies. Money launderers, Kennedy wrote, will rejoice to know they face forfeitures of less than 5% of the money transported, provided they hire accomplished liars to carry their money for them. His position was simple. If the violation was willful, forfeiting all of the unreported currency should be allowed. Kennedy also went after that cultural finding directly. He called it a patronizing excuse. It demeans millions of law-abiding American immigrants, he wrote, by suggesting they cannot be expected to be as truthful as every other citizen. The majority rejected that characterization outright. 4 justices agreed with him, 5 did not, and that one vote is the whole of the rule we live under now. So, what did Josep Bajakajian actually walk away with? A felony conviction, 3 years of probation, a $5,000 fine, and $15,000 of his own money gone. Kennedy called that a meager forfeiture, and he was not being kind about it. He did not walk away clean. The court never said he should. What the case established is narrower than his story, and much bigger. Before 1998, no court had ever enforced that ceiling. In the court's own words, it had never actually applied the excessive fines clause. After 1998, there's a test. The government has to be able to explain why the punishment fits what you actually did. Not what it suspected, not what it couldn't prove, what it proved. And that protection was won by a man who lied to customs, and then lied twice more about where the money came from. Which is usually how this works. Constitutional limits rarely get set by sympathetic people. They get set by whoever the government pushed too far.